Thank you, everyone. And without further ado, I'd like to introduce my panelists that I have on with us today. Peter and Julie, if you guys could just introduce yourselves and give us some background as far as, how long you've been working with co-op boards and how many years you're in the field, etc.
Sure.
Sure. Hey, everybody. I'm Julie Schechter. Pete Massa and I are the co-chairs of the co-op and condo department at Fox Rothschild. I have represented co-op and condo boards my whole career, so coming up on 16 years of all co-ops all the time. So it's been an interesting ride, and I'm happy to be here presenting today.
Yep,
Thank you, Julie.
I'm a little over 20 years in this field. This is what we do all day, every day, and love working with ACAM in your buildings.
Amazing. Thank you. And Jennifer, if you could just give the audience a brief background as far as your role at ACAM, what your department does.
Yeah, sure. Hi, everyone. I am the VP of Transfers and Closings at ACAM. My team manages the transactions that take place in our condo and co-op properties. We have our transfer agents as well as our closing agents and renewals team.
Amazing. Thank you so much, Jennifer. And last maybe least, I don't know. My name is Gil Maman. I am ACAM's Vice President of Business Development. I help boards throughout their search process, transition process, if they're thinking of joining ACAM, and feel free to reach out if you have any questions. So just to go over our agenda for today's presentation, we're going to go over what is this new law, give an overview, where it applies, and if there are any exceptions, the standardized application package requirements, what this law actually does require, the timelines for the submissions. I know that this is something many of our boards have asked about. This is probably one of the biggest sort of areas of potential concern for our boards is what does this timeline look like for us and how does this practically impact us? We're going to cover what summer recess tolling provision is, and how to apply for it, how to institute it, and then penalties for noncompliance with this new law, and recommended compliance steps to prevent any issues, and the application processing timeline. And we'll hear from my colleague Jennifer about that as well. And last but not least, preparing for compliance and how to go about preventing any issues from arising. Before we get started, I just wanted to provide a disclaimer. The information provided in this webinar does not and is not intended to constitute legal advice. Instead, all information, content, and materials available in this webinar are for general informational purposes only. So I guess, Peter, if you could just give us an overview of this law, what agency instituted this, when this goes into effect.
Sure. So this is a New York City law that's going to be overseen by HPD, the Department of Housing Preservation and Development. And part of talking about and introducing what it does do is talking about what it does not do. This law has nothing to do with the Reasons Bill and any limitations on co-op's right to accept or reject purchasers. This is strictly a timings issue. Time time periods for review and decisions on the application. And there's various time periods here that we will go through as this goes on, but that's all this law does is impose these time periods on a co-op's review process. This does not apply to condominiums. It's strictly co-ops.
Co-ops, exactly. And it goes into effect end of this July.
Correct.
Excellent. Okay. And if you can just talk about, you went over briefly, but where it applies, any exemptions, etc.
Yeah. So most co-ops, it will apply. There are certain regulated co-ops like Mitchell-Lamas and things like that where it doesn't, and co-ops with fewer than 10 apartments. And as we said, it doesn't apply to condominiums. And this covers basically if your building is covered, and most of the ACAM buildings probably are covered, you probably don't have many, if any, less than 10 units, then all kinds of transfers are covered, whether purchases, trust transfers, anything requiring board approval.
Excellent. If Julie, if you could just cover as far as what the standardized application package requirements are.
Sure. So that will vary from building to building, but they'll probably be rooted in the same primary documents that are requested in an application. Um, That's anything from tax returns and bank account information, employment verification, that type of thing. But one thing that's important for boards to do at this time is to review their applications and make sure that all the documents that they want to see are specifically and clearly listed in the application so that an applicant knows exactly what needs to be submitted in order to have what's considered a completed application. So it's good to periodically review your application package just to make sure it still complies with the law and it doesn't need any tweaking and it properly reflects the board's um, procedures. We recommend that boards do that every year or every other year anyway, but now is a good time to do that and to make sure that it has everything in it that boards like to see when deciding on an applicant.
An example of this is if you say tax returns on your application, you should say past 3 years of tax returns or 5 years or whatever you want and be really specific about what you're looking for.
Absolutely. And Julie, if you could just talk through the timeline as far as acknowledging submissions, what is the 15-day portion of this new law?
Right. So this law is bifurcated into two different sections. The first of which is the submission portion. So once an application is submitted, either the board or management, typically Jennifer's department at ACAM, will be the ones who will be vetting the applications and making sure that everything that was submitted is what was required under the application. Within 15 days, if Jennifer's department sees that there's something that's missing from the application, they have to, within that time period, let the applicant know exactly what's missing and ask them to submit it. If they fail to do so, and that notice from Jennifer has to be in writing and sent by both email and registered mail, which is unusual and cumbersome and a little bit ridiculous. But that brings up another good point. It's important to make sure on your application that you have a line for email for the applicant because you wouldn't necessarily have that. And also that you have their current address, that their current mailing address, and not just an address that they're at sometimes, because you will be sending this directly to them via both email and registered mail. But
Amazing. And so a question that a few boards have been asking me specifically, and this is what you touched on, is when does the clock start? And so the clock starts when management has confirmed a receipt of an application. Am I understanding this correctly?
yeah, that's right. So this has actually been a discussion internally in our office as well. I think most boards are probably using Domicile or one of the application submission platforms. And so it's whenever it pops up at ACAM sees that the application came in, that's when the clock is going to start ticking. But that doesn't mean just because the application came in that the application is complete. And that's what your transfer department is going to be vetting. And if it's not complete, then they need to, by both email and certified mail, let the applicant know, specifically identifying what items are missing. And that's why listing everything clearly and specifically in your application, what documents you're going to require, is so important. Because as Pete said, if you say tax returns and somebody submits 1 year, but really you wanted to see the past 3 years, well, now there's a question as to whether they complied with your with the terms of the application. So be specific so that it's easy for ACAM to make a determination whether the application is completed or not.
Excellent. Thank you. Okay. And so we have that 15-day period to determine, hey, did the clock start yet? And did I reach out and confirm to the buyers, we've received a complete application, et cetera. And then that leads into this next portion, which is the timeline for the board review and decision. I guess Pete or Julie.
I just want to jump in before we get to this because
Yeah, go
there's
ahead.
something uh, relatively important that we missed regarding the 15-day portion. So on the 15-day portion, if you fail to send that notice that either says your application has been received and is completed, or that we're requesting additional materials because your application was incomplete. If you fail to do anything, the law says that your application will be deemed complete. When I first read it, that was a little scary to me because I said to myself, does that mean that the applicant is accepted? No, it does not mean that. What it means is that the application is accepted as complete, meaning if they were supposed to submit 3 years of tax returns and they submitted two, because we didn't get back to them timely within that 15-day window, we now have to accept what they submitted as a completed application. And so if they're not giving you everything that you need, it's imperative that during those 15 days you let them know, or else you're going to close off your opportunity to go back and ask for it, with a few exceptions that we could talk about in a few minutes.
Yeah, and Jennifer and her department are working with domicile to put in procedures to do that and to be able to timely react during that period.
We're
Yes.
giving Jennifer a lot of extra work. I don't know that transfer agents are going to be happy about this law.
Well, the one thing is that we internally have an expectation of reviewing applications within 5 to 7 business days, which we stick to. So my team is used to reviewing applications in a timely manner, but definitely making sure that we want to make sure that if it is incomplete, to your point, Julie, that we're pointing out every single reason why it's incomplete and being very clear about that.
Absolutely. So yeah, practically speaking, this really doesn't change much in terms of time-wise, how long it would take you and your department to process an application. It's really just the added hoop of having to send registered mail, confirming that. Okay. I guess Julie or Pete, if you want to take this away, as far as, now once it's in the board's, once the ball is in the board's court, what does that actually mean as far as the 45-day rule?
Yeah, so the board has 45 days initially to review the application and make a decision. You can grant consent unconditionally with conditions or deny consent. Couple other things with that.
Just, Pete, just a point of clarification. So with conditions means, for example, if they're going to allow the purchase to go through, but they want to see a guarantor, or they want to have a maintenance escrow agreement whereby the board, takes a year's maintenance in advance in order to grant their consent. That's what a consent with conditions means.
Yeah, and during this period, the board is permitted to ask for supplemental and clarifying information in addition to the original application. So during the 45-day period, you can't ask for things that were on the original list that might have been forgotten. But if someone says, I have this $10 million property, you might be able to ask for an appraisal of the property to confirm the value or other clarifying items like that. The board can do that during that 45-day period. The board can also do a unilateral extension once for no more than 14 days, provided it notifies the purchaser before the deadline. Some boards have asked me if they should just do that every time. My answer to that was no, because you're going against the spirit of the law to me by doing that every time, and you should save those for when you really need them and do it that way. A purchaser can also agree to extend the deadline, and that will likely happen with things like interviews. Julie, you want to get into the interview part?
Yeah, sure. So most boards that we represent like to have an interview with the shareholder before issuing their acceptance. Because the determination as to whether or not you're accepting them or rejecting them or accepting them conditionally has to be issued within the 45 days. That means the interview has to happen during that time as well, which now makes the timeline a little bit tighter. You figure if boards have meetings every 30 days, then 45 days is not a difficult timeline to comply with. But when you throw in the addition of, having the board make its determination as to whether to proceed with an interview and then actually having the interview, 45 days seems a little tighter. So while they do have that 14-day cushion for an optional extension, our recommendation to boards is that you just unilaterally set an interview during that period. Find a date that works for the interviewers. But instead of finding a mutually agreeable date that could go extend beyond the 45 days, just set a date and say, buyer, if you prefer a different date, we can extend that 45 days and offer you a later interview. That way you're getting the purchaser to agree to extend the deadline, but you're making sure that you as a board are in compliance with the 45-day rule. As the alternative, if you were to go to the buyer and say, hey, can we find a day that works for everybody? Then suddenly you're looking 2, 3 weeks down the line, and that could cause you to be non-compliant with this law. So unilaterally setting it is what we think is the best idea, and make a caveat that you're willing to push it later to a more convenient time for the buyer, so long as they would agree to an extension of the deadline.
Excellent. Okay. And I know we have on here consequence of inaction. I just wanted to if you could just give a summary of that.
Yeah, so the law is pretty unclear about what happens. In the case of non-compliance after the 15 days, there is a default. The consent, it's deemed consent. It's deemed completed rather. In the case of the board not responding within the 45 days, the law is not entirely clear. And since it's a brand new law, there's obviously no case law or guidance on it. But we're telling our clients don't test the waters. If they say 45 days, do it. Treat it as a mandatory deadline. And I guess over time, either the law will be clarified or there'll be cases that come out. HPD will issue guidance as to what will happen if there's non-compliance. As far
Like a
as
lapse.
we don't know whether the purchaser will automatically be deemed accepted or what, but there are penalties that can be issued by HPD to the board if they don't comply. So,
And we'll get into that.
Yeah, and
Yeah.
that's just a general point with this law. It's new and it doesn't get into a lot of the issues that are going to come out of this and have specifics for each varying situation. So there is a sense of figuring it out as we go along, doing what's logical and going from there, because as Julie said, there is no cases. HPD has not issued any regulations on this. So we're all just trying to figure out the best practices based on the limited text of the law.
that's
Absolutely.
right. I do think over the next couple of months we'll see clarity on these issues, but for now, this is the best practice is to comply with the 45 days. And so that's our recommendation to all of the boards.
Excellent. And just Jennifer, I wanted to ask you a question, just practically speaking, as far as, pre this law going into effect, what is a normal timeline that we see as far as, from a time an applicant comes in requesting an interview to the time it's, scheduled and completed?
It really varies, but we're also advising if the boards do not have a set schedule of when they interview, then to also put that into place now, because that will definitely help in terms of just organizing themselves a little bit better, so that once the interview happens, typically shortly after that is when we receive the final decision.
Hmm.
So if that can be done in a timely manner, then we know we're going to get the timely decision within this time frame.
Okay, so that's a good best practice. Just have whatever it is, every second Monday of the month we're going to have as an interview window. Got it. Okay, excellent. And so many of our boards tend to take a break during the summer or recess during the summer. I guess Pete or Julie, if you could just give us, an overview of how this law looks at that and what boards can do to solidify that.
Sure.
Sure.
Go ahead.
Yeah. What I was just going to say is this is one part of the law that I actually think was well thought out. Most boards in our experience don't meet in August. Some of them don't meet in the summer at all. And the law really took that into consideration. And instead of keeping the tight timelines, the 15-day and the 45-day, they allow for a tolling of those periods during what they're calling summer recess. So they said that the board is allowed to have a policy that it has a summer recess sometime between July 1st and August 31st. So our recommendation to boards has been get a policy in place now, a formal written policy. And what that means is create a resolution, a couple of sentences that the board votes on and passes during a board meeting, and then it gets put into the minutes and codified as a policy for the building. Our recommendation is why not take the full amount of time and give yourselves the biggest cushion possible. And so the law says that you can have a summer recess between July 1st and August 31st. And so our recommendation to boards is that you set the summer recess. You say our building's policy is to take a summer recess between July 1st and August 31st. And so applications will not be considered at that time. Of course, if the board were to receive one and you have the type of board that does meet during that time, there's nothing that would prohibit you from doing it, but it does give you the extra protection in case you fail to comply with the timelines. You're not going to be, there's nothing wrong with that because the period with which to respond is told during that whole summer recess period. But
I
it
do
is
want to
very
note, oh, sorry,
important.
go ahead.
No, I was just going to, the thing I just wanted to emphasize is that it is important that boards have a formal policy in place. You can't just say, well, that's always been our practice. That's not good enough. What the law says is if the board actually has a policy on this, then you can take that position. And so we're encouraging all of our boards at this time to formally, in writing, codify it and put it in your minutes to make sure that it's a legitimate policy and not just something that is a hypothetical that everybody sort of goes with, which is how most of our boards work for something like a summer recess typically.
Got it. And as far as when you say codify, is it enough? I'm going to ask in a really, a layman's terms. Does that mean bring it up in a board meeting and vote on it? Does that mean putting it in the bylaws? What practical action does the board actually have to take to codify it?
Yeah, so I think it could be, and Pete and Jennifer feel free to weigh
Yeah.
in if you feel otherwise. But I think if the board voted on it at a board meeting and put it in the board minutes, that would be sufficient, and you wouldn't need an amendment to the corporate documents. However, I probably, once it was voted on, would add it to the application just so that applicants were aware of the building's policy. I think that just formalizes it a little bit more and prevents confusion when the timeline isn't followed, as far as responding to an applicant who applies during a summer month.
I agree. As long as it's in the minutes, that's fine. One thing I wanted to point out here that's a potential thing that could catch some boards. For instance, this year Labor Day's late. It's like September
Good point.
7th, and the recess period by law can only go through August 31st. So if you have timeframes that expire, even though they're told through August 31st, if they expire during that period before Labor Day and before everyone gets back into things, boards have to be aware of that and monitor it. It's not what boards probably view as when they don't meet. By law, it can only be July 1st to August 31st.
Yeah, that's a great point.
And now penalties for non-compliance. I guess Pete, if you could just give us, a quick summary.
So HPD has the right to implement these penalties for violations, 1,000 for the first, 1,500 for the second, 2,000 for third, and moving forward. someone would obviously have to complain to HPD to get them to do this, and they would have to show interest. But under the law, you can be subject to these penalties for violating any of these things.
Mhm. And this is what Julie brought up before. I just want to highlight this. It is unclear at this time whether a board missing the 45-day response window constitutes an implied approval, which I guess that's a legitimate concern a lot of boards have. The statute itself does not explicitly grant automatic transfer approval as a remedy, which, that makes sense, and that's what you brought up before. It's kind of
Mhm.
ambiguous as of right now.
That's right.
Recommended compliance steps. I guess
We
Julie,
we
if you
had
wanna,
yeah,
yeah.
sure. We had spoken about a bunch of these as we went through them, but these are the best practices, and boards should be going down this checklist and just making sure that they are in compliance with all of these things in advance of the law becoming effective. So one of which we discussed was reviewing and updating your application packages. We talked about being specific about the documents that you're requiring and making sure that everything that you want to see is listed. One thing that I noticed a lot of applications don't have is if you're buying in an entity like a trust and some other, depending, most co-ops only allow trusts, some allow LLCs and other entities, that you ask for a copy of that document with the submission. Sometimes applications don't ask for that. And as attorneys, we like to review that document for a purchaser takes ownership. And so it's important that you make sure that that's in your application and that the trust itself is being submitted as part of the application. Um, Next,
The other,
go
just
ahead,
on
Pete.
this, one other thing, ACAM and Domicile are working together to automate a lot of these
Hmm.
things. So I think for board members and managers, a key takeaway of this is really learning the functionalities of Domicile if you haven't done that yet, because a lot of this is going to be handled through there.
Excellent. Yes, that's true. And yeah, it's not like the old days where it was completely on the transfer agent to catch every single
Right.
mistake, and have to, meticulously go through with a fine-tooth comb every purchase application. We have some technology that can help with that.
Right.
Um,
So in terms of the acknowledgements, those will go out through domicile, through email, and also the registered mail piece. Um, excuse me. There'll also be a dashboard that allows us to see how many days are left for us in terms of the 15-day acknowledgement that needs to go out. There will also be a dashboard for board members so they can see how many days are left of the 45 days for them to put in their vote. So domicile is really upgrading the system to help us meet the compliance on both parts of this for the managing agent and also for the boards.
Absolutely. Now this next slide, this is actually my favorite slide in the presentation because it gives you a visual representation of the timeline and, what each step is. I guess, Julie, if you could
Sure.
walk us through, step by step.
I actually like this slide too. So we start with the application being received, and that's what starts the clock on the 15-day acknowledgement window. So we have 15 days from the date it's received to either say, okay, we have everything that we need in the application, or the application's incomplete, and here's what's missing. If if there's no acknowledgement, if you blow that deadline, then the application is deemed complete and you move into the next 45-day decision window. However, if you go back to the applicant and you say to them, we're missing 1 year of tax returns, we're missing certain financial information, um, then it's extended until they submit it. And the 45-day window wouldn't start ticking until you have the completed application. If the application is complete, then you would send a notice letting them know that, and you would move into the next cute little block over there, which is the 45-day decision window. And that's the board's time to review the application, decide whether it wants to issue its consent, deny it, or issue it with certain conditions, and also to conduct the interview. Um, Again, the board has the right to extend that 45-day window unilaterally. It can do it itself for up to 14 days. It can do it for longer, so long as the applicant agrees to a longer extension. And then after that period, you issue your decision. And just a reminder about the summer recess tolling period from July 1st to August 31st. This entire timeline is paused during that period and will start up again on September 1st.
Yeah, got it. That's actually something I thought to ask earlier is, what happens if I'm on day 30 and it's July 1st and, what happens? Does the whole thing start over later or do we just continue on from there after summer?
Yeah,
Um,
so also not entirely clear, but we're interpreting it as a tolling, meaning it's not going to start the clock again. It's just going to pause it where it is. So if you were on day 30, well, once September 1st rolls around, that's day 31.
got it.
Right, and that's why I mentioned the be really careful because regardless of when the practical recess period ends, by law, the clock starts again on September 1st.
Mhm. And so I do want to leave ample time for Q&A after this. We have a couple of questions in and that I definitely want to get to. But if you could just give us, an overview, either Peter or Julie, as far as preparing for compliance, or we can just skip straight to Q&A now, whatever you think is better.
I think we've talked about
A
most of
lot.
this stuff already. It's really just going through your application, passing the summer recess resolutions, and making sure everyone is on the same page about how you're going to do this. But I think we talked about most of these issues already.
Yeah.
Julie, did we miss anything?
No, I think we can move on. We discussed all of this.
Amazing. So let's go through Q&A. Um, what if ACAM's transfer department sees that all the documents have been submitted and deems it complete within the 15 days, but during the board's review after that window closes, we see that there are mistakes or need for clarification that require additional documentation to address?
So if there was something that was specifically listed as an application requirement and it was not submitted, but we sent them, ACAM sends them a letter and says, yes, we have a completed application. At that point, it's too late to go back and say, we made a mistake. We don't have a completed application. I mean, I suppose you could do it, but the purchaser doesn't have to comply and submit additional documentation at that time. However, if they did submit everything that was in your list, but you still feel like you need a clarification on something, like for example, if they submitted a trust because the document said to submit a trust, but you note in the trust that there were amendments to it, you may go back and say to them, we don't, you submitted the trust, you complied, but we're looking for clarity on, we're looking for the completed trust. Can you submit any amendments to the trust? Or if it's not clear from the finances, they list a debt on the debt side, but you're not exactly sure what that is. It's appropriate to go back to the applicant and say, can you clarify what this debt on your financial statement is? We see that you have an ongoing debt every month and we need clarity on that. So you can definitely go back for clarification, but you can't go back for items that were missed after you say that you had a deemed complete application.
Got it. Okay. And now you brought up trusts. This actually leads perfectly into another question. Does this law apply to a transfer to a shareholder's own trust?
Yes, it
Yes.
does.
It does.
At least as of now, without further clarification, for sure it does. Yes.
The
Uh,
way it's written, it applies to all transfers that require board consent.
Excellent. And what happens if you ask the applicants for clarification information and they are slow to return it or do not provide it? This is actually something I wanted to ask about as far as there's penalties for the board if they miss or management if we miss out on that 45-day window. But what if the other party is the ones who were slow to respond or whatnot, or cause any sort of delays.
The way I see it, this law was put into place to protect the applicant, to protect somebody who submits an application and has a board. Like everybody understands that boards are volunteers who, have day jobs and this isn't their primary concern. But on the other hand, applicants were sort of left without options if they were to submit an application and just not hear from boards for 60, 90 days. And so the intent of the law was clearly to help the applicant more so than the boards. And so I think if the delay is caused by the applicant, the board doesn't really have to worry about compliance with the deadline so much, so long as it was a legitimate request for clarity on additional documentation or a legitimately missed document. I think the board's not going to face any penalties if the delay is caused by the applicant.
Yeah, I agree. I think boards would have a good argument that while we're waiting for more information from them, the clock stops.
Okay. Yeah, that's an interesting, I guess,
It
situation.
doesn't fully say that, but I think it's a logical interpretation.
Yeah, I agree. I mean, the spirit of the law is to protect the applicant. And so
Right.
I think that's a strong argument.
Excellent. So we've gone through everything in terms of the Q&A. Let me see. Something actually just came in. Does this apply to the transfer of co-op shares from a deceased estate to a beneficiary? That's an interesting one.
If
Yes,
it requires board consent, yes. Like a
Okay.
transfer to a spouse under the proprietary lease often doesn't require consent, and maybe
that's
certain
the
other
one
family
exception.
members. But if it requires consent, that's the trigger.
Uh-huh. And one last question I had from this was actually something one of my colleagues asked me, and I think I know the answer, but I want to clarify for everyone, is does this affect the sublet process at all? Meaning, if your co-op does allow sublets, but with an interview, does this affect that process whatsoever?
No, it
Nothing.
does
No,
not.
this is for
That's
transfers
only. Got it. That's
only.
that's what I thought, and I just wanted to make sure, again, for anyone
Yeah,
who's
no, it's a great question.
not in the field. It's good to know.